There are your typical employment discrimination and harassment cases, and then there are your bombshell cases. And these bombshell cases are the type, for example, that involve sexual harassment allegation against the CEO of a company or a prominent politician, or cases in which a prominent athlete in town is accused of domestic violence or sexual assault, or a situation, for example, where the chief financial officer of a publicly traded company may have stumbled upon some massive accounting fraud that has resulted in shareholders being misled. These are the kind of cases that employers not only want to settle, but need to settle, or as I describe them in the office, as my Ray Donovan cases. Yes, I did just say Ray Donovan in this video. But and in those situations, obviously employers don't hire Ray Donovan, but what they do hire are what are called crisis management attorneys. And these are basically some of the best attorneys from some of the best law firms in the country who are specifically trained on responding to the sort of threatened litigation that can result in a catastrophic harm to an employer or a company or a prominent person. And in those situations, employers spare no expense, and oftentimes they pair their crisis management attorneys with PR firms, often in New York City or Los Angeles or Chicago, for example, and understand that they are loaded to bear with resources in these sort of crisis management matters. So victims in these bombshell type cases need to be just as deliberative as the companies are in selecting their legal representatives. And at Van Kampen Law, we do have experience in handling these sorts of situations in town and in North Carolina. I think one of the reasons why we're retained in these sorts of cases is that they require a certain versatility. On the one hand, as the legal representative of the victim in this case, I am a serious threat to the employer or a prominent person in the case. But at the same time, I also need to present myself as someone who can be, a problem solver. So it's this weird juxtaposition where, you're holding essentially, what's perceived as a loaded gun to, a potential defendant in a case. But in the same, on the other hand, offering a bulletproof vest that can eliminate the exposure in the case. And oftentimes it involves, moving back and forth, between those roles to get a case settled. And so it's a very difficult dance that needs to be navigated very strategically, because depending on how the negotiations transpire, the victim in these sorts of cases can leave, hundreds of thousands of dollars or even $1 million that could have been negotiated in a settlement. It can be squandered and lost. So every single component of this and phase in representation is critical in these sort of bombshell cases. Another thing that well situates us in these kinds of cases is our reputation as an aggressive litigation law firm. So, in crisis management type matters, there is no bluffing. You have to do what you threaten you will do. And if that means filing a lawsuit and you're given a deadline, that means filing the lawsuit the very next day. And understanding that there need to be repercussions. But the flip side of that is the plaintiff side employment lawyer in these matters also needs to be viewed as a reliable trading partner. And that starts first with how you approach the other side. So I don't think there's anything to gain by being unnecessarily judgmental or inflammatory when presenting a case of this kind at the outset. And in the end of the day, looking at both sides' interests, it's a business transaction. So we try to not sit in judgment and try to be diplomatic even in the beginning of a representation like that. But again, the flip side being that when it comes time to litigate, that we're going to litigate hard. So we give deadlines, hard deadlines with hard repercussions. But at the same time, we're offering an olive branch to this defendant as well. And to some extent, there needs to be trust built up between the two sides, because the crisis management attorneys and their clients need to trust that once they've negotiated a confidential settlement, that what is put in the vault will stay in the vault. And then finally, there's a time to be diplomatic, and there's also a time to be a fierce protector. There are certainly instances where, one of our clients is a victim in a high-profile situation, and where the other side starts to throw barbs. you know, and that's certainly a time where we bark back and bite back and remind them of who the real victim is in these cases.